Hello, everybody. Welcome to Topics and Decisions in Patent Law. I'm Joe Murphy.
I'm Reza Mollaaghababa.
Today we have a really good case, a recent case that came out last month. It's a Federal Circuit decision in the case Teva Pharmaceuticals versus Eli Lilly and Company. It's an important post-Amgen biotech patent case. It's an antibody case addressing written description and enablement under 35 U.S.C. 112. This decision is significant because it helps define the current boundaries of antibody-related patent protection after the Supreme Court's decision in Amgen v. Sanofi, which substantially tightened enablement requirements for broad, functionally defined antibody claims. So the dispute here involved two major pharmaceutical companies. Obviously, on one side was Teva Pharmaceuticals, who's both name brand and generic side, big company. And the other side was Eli Lilly, of course, another massive company with a substantial biologic and neuroscience portfolio. And the case arose from competing migraine therapies involving monoclonal antibodies targeting CGRP biology. These are anti-CGRP antibodies. So the products at issue are Teva's Ajovy product, while Lilly marks it Emgality. Both, again, are antibody-based migraine treatments and designed to interfere with what's called CGRP, which is the calcitonin gene-related peptide, or CGRP pathway. So we can discuss the biology a bit. So again, calcitonin gene-related peptide, CGRP, is a neuropeptide, kind of like a neurotransmitter involved in pain signaling and vasodilation. Researchers discovered that CGRP plays a major role in migraine pathophysiology. And during migraine attacks, the CGRP levels increase, sensory nerves become activated, and inflammation and pain signaling pathways are amplified. And of course, researchers were led to investigate whether blocking the CGRP activity could prevent or reduce migraine headaches. And so one successful strategy involves monoclonal antibodies. And then these antibodies could either bind directly to CGRP peptide itself or bind to the CGRP receptor. And the antibody today we'll be talking about binds to the peptide itself, which is, I think it's about 37 amino acids long. I'll bring up a slide about monoclonal antibodies generally. These are Y-shaped proteins. Antibodies generally are sort of Y-shaped proteins in certain embodiments, made of amino acid sequences, of course, which are coded by DNA sequences and comprise two heavy chains, these two longer chains, and also the two light chains. And these are held together by disulfide bonds. The bits on the end are the variable regions, or the complementarity determining regions, which are on the end of both heavy and light chains and are responsible for binding to specific target antigens, in this case, the CGRP. The constant regions provide stability and facilitate effector functions, such as binding to Fc receptor. The case here, the antibodies were humanized. So basically, the antibody has been raised in a mouse model, and then the constant region portions were taken off and replaced with human portions. So they're, quote, humanized monoclonal antibodies. So there'd be less immunological reaction when injected into a patient. And the patents at issue in the Teva case are directed generally to methods of treating headaches and migraines using humanized anti-CGRP antagonist antibodies. And I think, as will become clear in our discussion, the patents were not simply claiming all antibodies that bind CGRP or anything like that. They were, what's at issue here, method of treatment. The claims are focused on therapeutic methods involving administration of these anti-CGRP antagonist antibodies to patients suffering from headache disorders. And we'll see the distinction becomes really important later on. This is a representative claim, and this is claim 30 from patent number 8586045. And it just reads a method for reducing incidence of or treating headache in a human, comprising administering an effective amount of an anti-CGRP antagonist antibody, wherein said antibody is a humanized monoclonal antibody. And again, you can see this is a method of use, a method of treatment, and it's not claiming the antibody itself, which I think is really important. Now, the procedural posture of the case, again, this is a Court of Appeals of a Federal Circuit decision, right? So at the district court level, Teva had sued Lilly for infringement of these other patents. And at the trial level, district court level, the jury found that Lilly infringed the patents, that the asserted Teva claims were valid. However, after the jury verdict, the district court, the judge, overturned the decision through judgment on a matter of law. And the district court concluded the claims lacked adequate written description and enablement, and largely based on the reasoning in the 2023 Amgen v. Sanofi Supreme Court case, which we'll sort of compare and contrast them coming up in a bit. Lilly had argued the patents claimed an overly broad genus of antibodies without adequately teaching the full scope of the invention. And now it's up in front of the Federal Circuit, who's made their decision. So I think I'll turn it over to Reza now, who can kind of discuss the law and decision generally.
Thank you, Joe. As Joe mentioned, both the Amgen case and this case, the issue in both cases, the issues related to sufficiency of written description and enablement were very important. And in this case, as before we get into the details of the case, the US 35 USC 112 basically requires that the specification provide sufficient written description of the invention and also enable the invention. And these are really two distinct requirements, although there is some potential overlap in some cases. In other words, the inventor has to indicate through the written description that the inventor is in fact in possession of the breadth of the invention that is claimed and also has enabled the scope of the invention. And in Amgen case, of course, as we know, the court said that that was not the case. Here, also in the district court, as we go to the next slide, the court basically, at the trial level, it was decided that even though it's a method claim, but nonetheless the breadth is very extensive, and the disclosure was not really sufficient to entitle the applicant to the breadth of the claims. And in particular, it was mentioned that there was only one humanized species that was disclosed, and while the claim basically claims any anti-CGRP antibody. So at the district court level, the written description enablement were held against the patentee. But Teva appealed, and in the appeal, some of the issues that that Teva brought up was that basically the making such antibodies was routine. It was routine knowledge how to make them and how to humanize the antibodies. And also all those such antibodies would essentially provide the effect that the claim is talking about, reducing headache. And therefore, it didn't require research. It wasn't really a research assignment to figure out which antibodies would work to effect the result that the claim was directed to. And Lilly, of course, responded by saying that the humanized genus was not well known, and the mouse species that was disclosed shouldn't really count because we are talking about humans. And then also Lilly argued that the issue of the distinction between method and composition was really a semantic distinction without a difference, so to speak, because again, the claim is directed to all antibodies and really, in some sense, defines the antibodies by their function. And so, drawing an analogy with Amgen, the same holding should apply here, and meaning that there is not enough written description and enablement for these claims. So as Joe mentioned, this case went to the Federal Circuit, and the Federal Circuit basically took a very different view than the District Court. And Federal Circuit basically relied on this sort of distinction between method of treatment and composition. Basically, the Federal Circuit said they are not claiming the underlying antibodies, they are claiming a method of their use. And therefore, here, these antibodies could be, and they are also explaining how to make such antibodies. And there is also one issue here, and which I think we probably should discuss a little bit more, Joe, is that it really uh, hinged on this issue that all such antibodies, any anti-CGRP antibody, would work in this case. And this is sort of interesting because that became an important fact in this case, or an important assumption, so to speak, because if it weren't the case, then one could argue perhaps more effectively that this is a research assignment. Because if you, even if you make the antibody, how do you know which one would work? But they assumed that the court assumed that there was sufficient evidence here that one can conclude that all anti-CGRP antibodies would do the job. And that really tilted the scale towards the patentee and resulting in the court essentially holding that there was enough written description and enablement support. I don't know what you think about that issue, Joe.
Yeah, it's interesting. I think this is again, it's a relatively small peptide, and it's I think it's about 37. I apologize. It's either 37 or 39 amino acids long. And generally speaking, the the epitope that an antigen will target is roughly around about 9 amino acids or so. It can vary a little bit, but roughly that sort of scale. So there's a lot of different regions along which that peptide, along which an antibody could bind to. Now, antibodies are big, obviously, that you saw the slide earlier. And so, the mass of them, even if it maybe binds in different regions, could block the binding to the CGRP receptor or something like that. But, you know, that is an assertion of fact that, if I'd made an assertion of fact that as an attorney to an examiner, the examiner would laugh and be like, "You're going to need some evidence of that." Right. I mean, just saying all antibodies to this peptide will work and cure and treat headaches. I mean, I'm gonna need some evidence on that, or I would think you'd need some evidence on that. I think that's a real, say, a weakness, if I could say it that way. I I would again, and I think one antibody was disclosed
One
in the
humanized
spec.
antibody was
Right. So
disclosed,
it's
right?
not like, oh, we tried, whatever, how many, 20, whatever. And they all worked. They all treat headache. And the other thing I thought was interesting was I don't think humanizing antibodies is off the shelf at this point. Like I don't think it's quite as straightforward as the court made it seem.
Hmm.
Um, I don't know that it's that easy. I don't. It's not like you're doing a PCR where you make a couple primers and it's going to work. I mean, it's I don't know. It's a lot more complicated than that. So that's two things I think that are interesting here, where you know one of skill in the art is going to have to figure out, okay, I've got this, just say 37 amino acid long peptide. Where is my antibody going to bind so that will have this effect on headache? That's one. And then two, now I got to humanize it because if it's still got murine constant regions, I'm going to get immune reaction in my patients. So that's another complicating factor. Um, are, are
But I
are
guess the
those
court
within
wasn't
one of skill in the
really.
art to easily do, or not easily, but one of skill in the art could do that reasonably? I don't know.
I guess you're right, but the court ultimately was not persuaded by those by those arguments because they said, oh, you can figure out what the sequence is, you can. So they basically assumed that all these steps are fairly routine. But then I think as you said, Joe, the important thing was that they made the assumption that all such antibodies would work. Because if
Mm,
that wasn't the case, this could have gone differently, I think. Because then one could argue that, well, maybe you can make all these antibodies and that's a routine process. But if you don't know if all of them would work, then again becomes a research assignment, so to
mhm.
speak. Meaning that then you have to screen all these
Right.
multitude of antibodies to see whether they have the desired effect. So that it seems to me was very central to the case. And as you said, it's also quite a bold assertion that
Right.
all antibodies would work. But nonetheless, I think the court assumed that that's the case.
I wonder what would have happened, you know, in a theoretical world where Lilly could have said, "Hey, we made an antibody that bound CGRP and it doesn't treat headache." You know, if they could have showed a
If they could
counterexample,
have shown a
just said,
counterexample,
"Here's
but
one it doesn't
yeah,
work," you know, or
yeah,
whatever.
yeah.
That would have been interesting, but I
Yeah, but
no, it didn't work.
that wasn't
And the
in the
other thing
case.
about
Yeah.
these antibody cases, which I think is interesting, and you know, and I think we had this discussion during our discussion of the Amgen case as well, which is different again because you know that those were compositional claims, right? They were claiming the antibodies themselves, and they were claiming them purely on a, there were two elements in the you know what I'll put up a picture of the one of the claims from the Amgen case. So there's two aspects or two elements in the composition claims in the Amgen case, the Supreme Court case. You've got to have a binding function, and they define the binding site, and then you've got to have a blocking function, so it would block the binding of this PCSK9 peptide or a big protein. So you had two. So you're claiming the structure based on the function, right? You're only defining here's I want to have it bind and I want to have it block, but that's it. You had no sequence, and you know it loses on enablement. I mean that's okay, I guess. Yeah, I mean I don't necessarily disagree with that. But also, you know, why did it meet? Why did that one meet written description? Now this, you know, and this one did too, right? Because they looked at it at written description as well as enablement. And said, well, it's enabled because, hey, any of the they're straightforward for one of skill in the art to make, and all of them work, which is great. I mean, that's okay. And then, you know, okay, but I've got one example. Have you described the entire genus of all possible antibodies that can you know, do you have possession of all antibodies that can do this? You know, that kind of thing. So I would think, I don't know, enablement, enablement, you know, people fall back on a lot, but written description I think is really tough. If you start applying written description to some of these, it's really difficult.
Yeah, that's a good point. And actually, there's a slide we have here that basically talks about the underlying written description law, and and the court has indicated that, you know, you can have a very broad claim to a genus, but you have to either show that the genus is well known in the art and used as a component, you know, of the invention, or they have, you know, disclosed enough representative species that you can sort of be entitled to the genus. So, but clearly here, the court makes a very clear distinction between composition claims and method claims, which of course Eli Lilly brought up some previous cases and to show that in some other cases uh, the court had indicated that certain method claims that, according to Eli Lilly, were similar to these were held not to have had an, you know, sufficient written description requirement. But the court distinguished all those cases. For example, there was one case where the court said, well, here they are, and this is, if I can find the name of the case, yes, uh, Hirschler case. And the court said, well, this is really a different case because the court said the analogy of the method claim in that Hirschler case is a claim that says we're gonna treat X by using something that treats X. So it's almost like a tautology. And So of course there is no written description or enablement, because what is X? I mean, it's sort of like going in circles, so to speak. So in each case, they managed somehow to distinguish the previous cases that Eli Lilly had brought up, and so in the precedent didn't really help
Yeah,
Eli Lilly.
I don't, I understand there might be a different enablement and possibly written description analysis for method of use or method of treatment claims, however you want to phrase it. But if you're claiming a method of use of a biologic, that biologic should be held to the same standard, theoretically, as a biologic you're claiming in a compositional claim. You know, if me as a skilled practitioner in the art is trying to treat a headache with a biologic, I need to be able to make and use a biologic. You know, whether I'm just making it, qua biologic so I can sell it, or I'm making it so I can use it in my method of treating someone with a migraine. It seems like it should kind of be the same. Do you disagree?
Yeah, I mean, no. I think from a sort of pure legal point of view, I agree. But maybe there is a practical aspect to it that in this case, they were not foreclosing the use of these antibodies for other applications. So it was sort of a narrower scope as a practical matter than claiming the antibody itself. Because if you claim the antibody itself, essentially you cannot use it for anything, right? I mean, and here they're saying, well, this is sort of for treating headaches, but the same antibody can be used for other types of applications. So maybe there is a practical aspect to it that makes the distinction perhaps a little bit more understandable. But from a pure
So,
legal point of view, it's
yeah.
difficult to make the distinction. Yeah.
Well, it's a good argument that you raise. I think the fact that there's a limit on the universe of the genus that you're claiming, right? So in a method of treatment claim or method of use claim, the biologic has to work within that method. So it's sort of limited. Like you said, I could see that. So if you're claiming the antibody, you're precluding use for all other uses. Whereas in the method of treatment of if your method of treatment of a headache, really you're kind of limited to that one use, and people could use that biologic for other things. I could see that. I mean, I could be persuaded by that. I think that makes
Yeah,
sense.
it's sort
I
of
was
like
looking
a
at
preemption argument, but on the other
yeah,
hand, it doesn't jive well with the written description and enablement law,
right.
because you still have the same issue. Are you really entitled, based on your disclosure, to this breadth of this kind of scope of the claim?
Yeah, I think we're back to the all antibodies that bind CGRP will treat migraine. I would really like to
I think
see,
that was really important, because I
yeah,
think if you didn't have that, my feeling is that it would have been a lot harder to argue this case,
right,
because then you would say, okay, you make the antibody, but how do you know it works?
right,
And then it would be back to this issue of doing essentially, this is just a research assignment that you have to go and figure out what
right.
works.
Well, I think this is a great case. And it's a CAFC case, and like, it was decided at the time of us taping a month ago. And so we're not quite, it's been remanded back down, but there could be an appeal. So we'll see what happens with the case. We'll keep an eye on it. I think it's going to be interesting to see if it ever gets back up to the Supreme Court. It'd be really interesting to see what they decide. I don't know if it would, but I think it's a great case, and we'll keep an eye on it.
Absolutely.
Yeah. So,
Well,
well, thanks.
thanks,
It was
Joe.
great speaking with you about the case, Reza.
Thank you.
All right.
Bye-bye.
Talk to you later. Bye bye.